All rise, we will obey. Please be seated.
Counsel for Mr. Mladić.
Madam Presiding Judge, good afternoon. Can you hear and see us clearly?
I can hear you. I am waiting. Yes.
Yes, we are ready to proceed from our end, Judge.
Yes. You may proceed.
Thank you, Your Honor. I will turn to the second part of my submissions on ground 2. The trial chamber's approach to rebuttal of adjudicated facts was correct. There is no dispute between the parties that an adjudicated fact can be rebutted by presenting reliable and credible evidence contradicting the adjudicated fact. That one way of presenting rebuttal evidence is for the defense to present contrary evidence during the defense case, and that prosecution evidence can also rebut adjudicated facts, as recently confirmed in the Karadzic appeal judgment in paragraph 129. The test for rebuttal does not change depending on who brings the evidence that supposedly rebuts the adjudicated fact. For rebuttal through prosecution evidence, this means if the defense can point to prosecution evidence contradicting an adjudicated fact, and if that prosecution evidence is reliable and credible, the adjudicated fact is rebutted. The trial chamber applied this throughout the judgment and found in a number of instances that prosecution evidence did rebut adjudicated facts. I'm referring, Your Honors, for example, to trial judgment paragraph 787, 829, 1156, and 1263. But not every weakness in the prosecution's evidence amounts to rebuttal of the adjudicated facts. The defense's general statement that rebuttal evidence comes in the form of identifying weaknesses in the evidence presented by the prosecution is not correct. Weaknesses in the prosecution evidence only amount to rebuttal if they contradict the adjudicated fact. We have explained in paragraph 33 of our response brief that the trial chamber's reference to clearly contradicting and the way it applied it is consistent with the approaches of other ICTY trial chambers, which considered that evidence was not contradicting when it was equivocal, inconclusive, not outright contradictory, or merely stating that the adjudicated facts are not correct. Moreover, that the prosecution evidence is merely insufficient to prove the point made by the adjudicated fact does not rebut the adjudicated fact. This is because the prosecution does not have to bring evidence supporting the adjudicated facts. As the Karadzic Appeals Chamber confirmed, adjudicated facts do not require corroboration. This would undermine the judicial economy function of adjudicated facts. And I refer your honors to the Karadzic Appeal Judgment, paragraph 452. And in this case, the trial chamber explicitly limited the prosecution's ability to bring evidence that was duplicative of adjudicated facts. Trial judgment, paragraph 5258. It therefore does not matter and does not rebut the adjudicated fact if the prosecution evidence in and of itself was insufficient to prove the same point also made by the adjudicated fact. Mladić does not show error in the trial chamber's approach to rebuttal of adjudicated facts. I would like to end my submissions on ground 2 with a few words in relation to one particular adjudicated fact. Adjudicated fact 1476, which my learned friend Mr. Ivičić emphasized in his submission in relation to Srebrenica yesterday. According to Srebrenica-related adjudicated fact 1476, between 7,000 and 8,000 Bosnian Muslim men were systematically murdered. The trial chamber relied on this adjudicated fact in relation to the numbers of victims of the Srebrenica operation in trial judgment paragraph 3007, and to establish the chapeau elements of crimes against humanity by referring to the overall situation in the enclave in trial judgment paragraph 3042. The chamber did not rely on this adjudicated fact to establish Mladić's individual criminal responsibility for killings in Srebrenica, nor for his sentence. Contrary to Mladić's claims in his reply brief at paragraph 35, the prosecution did not concede that the chamber relied on it to establish Mladić's intent or his significant contributions to the Srebrenica JCE. For the Srebrenica killings of which Mladić was convicted, the chamber carefully considered the status of the victims, and in case of doubt, whether they were actively participating in hostilities at the time of killing, it excluded them from the victim count, as Ms. Baig has explained this morning. And I refer your honors to the judgment pages 1608 through 1610, which refer back to the detailed analysis in chapter 7 of the judgment. Since the chamber did not rely on this adjudicated fact to establish Mladić's individual criminal responsibility or for his sentence, there was no need for the chamber to analyze whether all of the 7,000 through 8,000 were not actively participating in hostilities. Nor can Mladić show prejudice by the lack of this analysis. For the same reasons, Mladić cannot show prejudice by the chamber's denial of his motion to extend the defense case to call a witness in relation to this matter.
Could you kindly pause? Thank you. Madam Presiding Judge, can you hear and see us now?
I can hear you, but I cannot see you or the courtroom.
Yes, we will establish connection.
Thank you.
Presiding Judge, are you able to see us now?
Yes, indeed. We may
Okay.
proceed.
Thank you.
Thank you, Your Honor. I will pick up where I left off. So since the Chamber did not rely on this adjudicated fact to establish Mladić's individual criminal responsibility or for his sentence, Mladić cannot show prejudice by the Chamber's denial of his motion to extend the defense case to call a witness in relation to this matter, an argument Mladić makes in ground 8A of his appeal. This adjudicated fact was also not rebutted. In paragraph 3007 of the judgment, the Chamber found the number of 7,000 to 8,000 is consistent with a smaller number of victims from the incidents in Schedule E of the indictment. The organized executions and opportunistic killings listed in Schedule E were never meant to provide a complete account of victims of the Srebrenica operation. They are not even a complete description of Mladić's individual criminal responsibility, which is not limited to scheduled incidents. There's therefore nothing inconsistent or contradictory between the adjudicated fact that during the Srebrenica operation, 7,000 to 8,000 Bosnian Muslim men were murdered, and the smaller number of victims in the incidents listed in Schedule E. Mladić fails to show error in the trial chamber's treatment of adjudicated fact 1476. Ground 2 should be dismissed. Your Honours, let me end the prosecution's submission today with ground 9, sentencing. Ratko Mladić is one of the worst war criminals who has ever faced justice before an international tribunal. He is responsible for the killing of thousands and the forced displacement of tens of thousands Bosnian Muslims and Croats from their homes, for their mistreatment in a system of detention camps, for grave sexual violence, and for destruction throughout Bosnia and Herzegovina. He carried out a campaign of shelling and sniping against the civilian population of Sarajevo to spread terror. For over 3.5 years, the civilians faced extreme fear and did not feel safe anywhere in the city. He is responsible for genocide against the Bosnian Muslims of Srebrenica, the killing of the men and boys, and the removal by force of women, children, and elderly, and for taking UN personnel hostage. In all of these crimes, Mladić was a key player whose role was central or instrumental to the commission of those crimes. Mladić's crimes not only affected the direct victims, his brutal legacy will affect generations. Loved ones were separated, families displaced and put through incredible hardship. They bear the pain of having their relatives killed and abused. Communities have been shattered by the atrocities committed by Mladić. Considering the nature, scale, and brutality of these crimes and Mladić's important role, life imprisonment is the only conceivable punishment. The crimes of this case are some of the gravest, and the crime base is one of the largest attributed to an accused at the ICTY, comparable with a case against Bosnian Serb President Radovan Karadzic. The Mechanism Appeals Chamber raised Karadzic's sentence from 40 years imprisonment to life imprisonment because a 40-year sentence was so unreasonable and plainly unjust that it constituted an abuse of the trial chamber's discretion. Life imprisonment was the only sentence that adequately reflected the extraordinary gravity of Karadžić's crimes, their sheer scale, and the systematic cruelty with which they were committed. That's the Karadzic appeal judgment, paragraphs 773 and 776. Mladić's crimes largely match the ones for which Karadzic was convicted. For Mladić too, life imprisonment is the only conceivable sentence. Nothing less than the maximum sentence is appropriate. Indeed, other cases, which dealt with only parts of the crime base for which Mladić is responsible, have also resulted in life sentences. Mladić's subordinates, Popović, Biara, and Ptolemir, were sentenced to life imprisonment for committing genocide in Srebrenica. Galić, another one of Mladić's subordinates, received a life sentence for shelling and sniping in Sarajevo during a shorter period than Mladić. All of them were his subordinates, and all of their conduct is attributed to Mladić. This not only shows that life imprisonment is the only adequate sentence, but also that the gravity of Mladić's crimes far surpasses the threshold for life imprisonment. The horrors he committed in each of the three major components of this case call for a life sentence on their own. In our response brief, we have set out why the trial chamber did not commit an error in its consideration of aggravating and mitigating circumstances. But even if the chamber committed an error, in light of the gravity of the crimes, no error in relation to these circumstances can reduce the sentence below life imprisonment. Any other sentence would, in the words of the Karadzic Appeals Chamber, be unreasonable and plainly unjust. Ground 9 should be dismissed. For the remainder of the grounds, we rely on our response brief. To conclude, Your Honours, Mladić's appeal should be dismissed in its entirety and his life sentence should be upheld. This ends the prosecution response.
The defense want to start to respond now, or we take a break and you respond after the break?
Thank you, Your Honor. That is actually what we were going to recommend, since we do have some of our reply in written form, and we'd like to print that out so that the translators and the court reporter have an easier time following us. And I think we hopefully then will even conclude earlier than the time allotted. So taking a break now of, 20 minutes or so should allow us to print up copies of what we do have already prepared. Some of it will be sui sponte, but we do have some prepared notes that will help the translators. So I would ask for the break at this time.
Very well. We adjourn and resume 40 minutes from now.
All right, vous pouvez vous lever.